Straight ahead on Law and Crime Daily. Opening statements are presented as R&B singer R. Kelly faces federal sex crimes charges. And what caused a string of delays in the Parkland school shooter penalty phase trial.
We're here for a status on the Dauber hearing that was scheduled for Monday, which I understand is no longer necessary.
Plus, the Sandy Hook civil lawsuit in Connecticut moves forward amid accusations that Alex Jones's attorneys committed ethical violations. But first, opening statements are presented as an Ohio man stands trial for the murder of his wife.
They were walking down the bike path, walking in a westward direction, and eventually they found the remains of Emily Noble.
Trauma is almost an understatement as to what Emily had lived through.
Hear from both sides in the case of Matheau Moore. Law and Crime Daily, covering court cases from coast to coast. Welcome, everybody, to Law and Crime Daily. I'm Jesse Weber. Opening statements are presented in the staged suicide trial of Matheau Moore as he faces murder charges in the 2020 Ohio death of his wife, Emily Noble. Noble was reported missing on May 24, 2020, after celebrating her 52nd birthday with her husband. Hundreds of volunteers conducted search parties, but Moore reportedly never took part. In September, Noble's decomposing body was found in a wooded area in Westerville, Ohio, not far from the couple's home, with a USB cord wrapped around her neck. Authorities say her death was staged to look like a suicide, but evidence pointed to a homicide. Dental records had to be used to identify the body, and an autopsy revealed Noble suffered multiple facial and neck fractures. Moore was arrested 7 months later and charged with murder and felonious assault, though detectives have not announced what led them to suspect Moore. In their opening statements Tuesday afternoon, prosecutors told the jury that Moore waited hours before calling a friend about Noble being missing and that his statements after her death were inconsistent. Prosecutors also told jurors of when the victim's body was found in the woods.
You'll hear testimony from the three individuals that found Emily, that they were walking down the bike path, walking in a westward direction, and eventually they found the remains of Emily Noble, found what they were looking for. You'll hear testimony that they called Westerville police, and at that time, Emily was finally found. You'll see pictures of the scene taken from BCI. You'll see pictures of Emily and how she's situated. And what you'll see is that she was in a kneeling position under a tree that was about almost 6.5 feet tall, and was found with a micro USB cord wrapped around her neck.
Moore's defense attorney told the jury that prosecutors have a lack of evidence in this case and that Noble's mental health history proves Moore is innocent.
The state in its opening talked about Emily's traumatic life. Emily's first husband killed himself by shooting his head in 2011. A year later, in 2012, the evidence will show one of her very good friends killed herself. The evidence will show that. In 2017, her brother-in-law, by marriage, so Mark's brother, kills himself. In 2019, Joey hangs himself in a park from a tree. Trauma is almost an understatement as to what Emily had lived through. But Joey, her stepson, and again, our openings aren't arguments, but the state said Emily was passionate about Joey. And the evidence will certainly support her passion and love for Joey and what that loss in 2019 did to her, emotionally and physically.
The first witness called to the stand after opening statements was Noble's sister, Amy Thomas. On direct examination, she testified about Moore alluding to not wanting to find his wife under a tree just a day after she went missing.
Turn your attention to May 26th. Did you, let me ask it this way. Had you received communications from people who were interested in going out to look for Emily?
Yes.
And did you communicate that to Matt in that same Facebook chat that had you, Matt, and Emily?
Yes.
And what was his response to you talking about a search party?
This I remember. He said he didn't want to go out and look to find her dead under a tree somewhere. Isn't that what search parties are for? And he said he wanted to just let the police search for her.
All right, let's talk about this. Joining us today is former senior homicide prosecutor and trial attorney Bernarda Villalona and former prosecutor Melba Pearson. It's great to have you both here. Melba, I'll start with you. Let's start with the openings, right? What stood out to you the most? Who do you think gave the better presentation overall?
Well, I would say that the prosecution gave a much more scientific, like bullet-pointed kind of presentation. There wasn't a lot of passion, there wasn't a lot of emotion. And again, based on the evidence, there may be enough of that in the prosecutor's case that the prosecutor decided to do a more understated opening. But I would say that the defense's opening is much more passionate, much more trying to connect with the jury right out the gate and talking about the pain that the victim endured throughout her life, including the loss of her son, and how that may play into their defense. So I think they went about it in different ways. The prosecutor was much more understated. The defense was much more passionate and trying to connect.
So moving away from the opening statements, let's move on to the witness testimony. Moore didn't want to search for his wife and find her dead under a tree, and it kind of looks like a red flag until we learn that his son was found dead in the woods the year before that. So Bernarda, what do you make of that? Is it not such a bad statement?
So it's not such a bad statement. What we got to think, what we think is normal is definitely probably not normal to this defendant. In terms of what's going on here, it's sad that the sister had to come in and testify. She's testifying about the last moments that she had with her sister. And now as she thinks about things just weren't normal, what was said by her supposed husband. And all of those are coming up as red flags, and those red flags may do him in at the end. But there's still, I think, a lot to go on. We just got to wait and see.
We do, and it's an interesting start to what is a really unique trial and a unique case. Still ahead on Law and Crime Daily, Alex Jones's attorneys appear in court for yet another disciplinary hearing. But first, a jury is seated and opening statements are presented in the second federal trial of disgraced singer R. Kelly. Welcome back, everybody. A jury is seated and opening statements are presented as R. Kelly's federal trial in Illinois begins. The once celebrated R&B singer faces 13 federal charges in Illinois, including receiving child pornography, enticing minors into illegal sexual activity, and obstruction of justice. Back in 2008, Kelly was acquitted by an Illinois jury for creating a video of himself having sex with a 14-year-old girl. Now, at the time, the girl and her parents denied involvement, and the alleged victim refused to testify. Federal prosecutors say that witnesses and their families were threatened and paid off in that case. But this time around, prosecutors say the alleged victim and several other women victimized by Kelly will take the stand. Kelly maintains his innocence and pleaded not guilty to the charges. In Wednesday's opening statements, prosecutors told jurors that Kelly went to great lengths to cover up his sexual relationships with multiple minors. The defense countered, saying Kelly has been portrayed as a monster by the, quote, criminals that are his accusers. Last year, Kelly was convicted on separate federal charges of racketeering and sex crimes. In June, he was sentenced to 30 years in prison. Melba, the ongoing saga here. I mean, this comes less than 2 months ago when Kelly received a 30-year federal sentence for similar crimes. Can we expect another conviction here, or maybe he'll get acquitted?
Listen, anything is possible, Jesse. We know that trials are unpredictable. The folks that you think you have solid that are going to come in and testify may get cold feet at the last minute. They may get threatened again. Any of those things are possible. But I find it highly unlikely that this case would result in anything less than a conviction because of the fact that the federal prosecutors had time to prepare. They had time to shore up their witnesses to make sure that they will participate. So I think it's highly likely that the feds are going to notch another conviction on their belts with regards to this case.
Bernardo, this is an interesting point, and that's that Kelly's defense team, they pushed for a jury to not see the docuseries Surviving R. Kelly, but a judge denied that request. So it makes me wonder, are these jurors well aware of Kelly's past?
That's going to be a problem, Jesse. I think it's going to be a problem in terms of for the prosecution that R. Kelly, if he does get convicted in this federal case stemming out of Illinois, that he probably has some strong appealable grounds, especially since you're talking about people on that jury. We don't know if this is for sure, that people on that jury have already seen the docuseries. And the reason why is because they're expecting that at least one or two people that were in those docuseries are going to testify at this trial. So that means that they've been predisposed to the allegations in this case. And it makes it hard for them to be a fair and impartial juror if that is the case.
And talk about the jury and videos, it's my understanding they're actually going to see these videos of these alleged sex acts, which is, really something in this case. So it'll be hard for the defense to refute that. Switching now over to California, where a Los Angeles County Sheriff's Department chief apologizes to Kobe Bryant's widow after photos of his deadly helicopter crash were shared. This comes as part of Vanessa Bryant's civil lawsuit against Los Angeles County. Bryant argues that first responders inappropriately shared photos of the crash to people outside the fire and police departments. In January 2020, the NBA star, his daughter Gianna, and 7 others were killed when the helicopter they were flying in tragically crashed. Chief Jorge Valdez took the stand on Tuesday, where he apologized to Vanessa Bryant as well as co-plaintiff Christopher Chester after learning that no apology had ever been made before. This apology echoes opening statements from Bryant's lawyer, who told jurors to make note of first responders who apologized while testifying, saying that previous apologies had never been made. And also in California, jurors hear from a canine cadaver dog handler in the death of Kristen Smart trial. 19-year-old Smart went missing back in 1996 when she was a student at California Polytechnic State University. Though her body was never found, she was legally declared dead in 2002. Father and son Ruben and Paul Flores now stand trial in connection to Smart's murder. Paul Flores was the last person seen with Smart before her disappearance and faces charges of murder. Ruben Flores is charged with accessory after allegedly helping hide the body after the fact. On Monday, a canine handler who searched Cali Poly in 1996 took the stand, and she told jurors that 2 separate police dogs gravitated toward Paul Flores' dorm. Both dogs pointed out the side of the room that Flores lived on and motioned towards his bed multiple times. Now, this trial is not being recorded or live streamed due to orders by a California judge. Coming up on Law and Crime Daily, after multiple delays and a trial hiatus, the Parkland school shooter is back in court. Plus, yet another defamation case on the docket for Alex Jones, why Wednesday's disciplinary hearing may not be the last. Welcome back, everybody. The Connecticut civil case against conspiracy theorist Alex Jones will move forward with jury selection beginning Thursday as he faces lawsuits from several victims' families in the Sandy Hook massacre. The decision comes days after a Texas jury decided the InfoWars host should pay nearly $50 million in defamation damages to the parents of a 6-year-old who was killed in the 2012 elementary school shooting. This all stems from Jones's comments made to his audience after the massacre when he said that the shooting of 20 first graders and 6 educators was a hoax staged by government actors in order to push gun control. Jury selection will begin Thursday for the lawsuit filed by 8 other families as well as an FBI agent who responded to the shooting. The decision to move forward with the case came after a judge stripped Jones of the protection that he was seeking when he put the parent company of InfoWars into bankruptcy. The topic of a hearing on Wednesday was Jones's attorneys, as 2 of them are facing disciplinary hearings for how they handled confidential files, including medical and psychiatric records of plaintiffs in the case. The judge asked for dates and specifics about the sharing of the files, but the Zoom hearing ended before any decisions were made of whether ethics rules were violated.
Any recording is ordered to be stopped. At this point, we are going to go off the record. I will not be staying on, and we will now book. We're going to just book 2 days before the start of evidence in these lawsuits too. And it may be that we just need 1 day, but we'll book the 2nd day just in case. All right. Thank you, counsel. We're adjourned.
All right, a little anticlimactic there. But Melba, we've already seen multiple disciplinary hearings for Jones's attorney. Shouldn't this be a red flag for their client? And maybe also, shouldn't the attorneys know full well how to deal with confidential documents?
At this stage in their careers, they absolutely should know how to handle confidential documents. But again, it may speak to the type of case that this is, right? I mean, you're looking for counsel to represent you in a very sensitive matter. Obviously, we know that everyone has the right to a defense, et cetera, but at the same token, do you really want to put your name on the line for this type of defendant and for these types of charges? You may be seen as co-signing some of the horrible things that he said about these families. So I think that speaks to the types of attorneys that might be willing to take on this case as opposed to others. So I think that may be what's at play here.
Bernarda, it feels like deja vu, doesn't it? I mean, didn't we just cover an Alex Jones defamation trial in Texas? Do you think that this Connecticut trial is going to be any different?
I'm hoping that the judge will have more order in her courtroom in the Connecticut trial, in the sense of not letting Alex Jones do what he wants to do. Because remember, he also didn't appear for several of, I think, not even for the damages section to find out how much he's going to have to pay. He wasn't even in there for punitive damages. So let's see if he even shows up for the trial, for the entire trial. But we're dealing with the same subject matter. We're dealing with all of his lies and lies and lies about what actually took place and how he hurt these families that have been grieving since they lost their loved ones.
Well, I'll tell you what I'll be looking out for. If he decides to go on InfoWars during the course of the trial and comment on the trial like he did last time, where he made fun of the jury and the judge and the plaintiffs, we'll all be on the lookout for that one. When we come back, the Parkland school shooter penalty phase trial. Defense attorneys explain why this week's Daubert hearing was canceled and the evidence will no longer be presented. Welcome back. The Parkland school shooter is back in court following a series of delayed and canceled hearings. Last October, the shooter pleaded guilty to 17 counts of murder and 17 counts of attempted murder. And it's now up to a Broward County jury to determine whether he receives life in prison or the death penalty. After a recess in court last week, a Daubert hearing was scheduled to be presented on Monday. The hearing was unexpectedly canceled when the defense said it would no longer present on issues that were brought up by prosecutors. Now, the Daubert hearing was meant to discuss a series of the defendant's brain scans that may have shown brain damage. At a status hearing on Wednesday, both sides explained why the evidence wouldn't need to be presented.
We're not relying on those, the specific things outlined in the state's Daubert hearing. So that's why the hearing is no longer necessary, because we're not relying on those types of scans or comparisons.
That the state was objecting to.
That's correct, yes, ma'am.
State, are you in agreement with that?
Judge, yes, and just for the record, it's the neuroquants, the diffusion tensor imaging, which is DTI, quantitative EEG, and the MIM neuro. That was the basis of the state's motion to exclude under Daubert. We received an email Sunday night from the defense that they no longer intend to rely on any of that evidence in their mitigation presentation. So obviously there's no need to go forward with the hearing. We would ask, however, that the court colloquy the defendant on this issue.
Now, the judge ruled that when both sides present an agreed order, she will sign it and then colloquy the defendant. Melba, the defense won't use the brain scans that the prosecution opposed, but the defendant still needs to reply to a colloquy. So does that mean that that we're going to hear from him in court? What do you think that might look like? Break it down for us.
Yeah, so basically, the judge asked the defendant a series of questions to make sure that he understands that those scans are not going to be used, that he agrees with the strategy that his defense counsel is using, and that he is fully aware and is willingly entering into this next phase of the trial. So again, he's agreeing and understands what's happening. So that way, on appeal, there's not that issue of, well, I didn't agree with what my defense counsel was proposing. I really did want those scans to be entered into evidence as mitigation. So that's to make sure that that issue then gets resolved. And he is saying on the record that he understands what's going on and he agrees with the path that's been chosen.
And it's important because there has been a question if he understands what's going on during the course of this. And so, Bernarda, we know that court proceedings are expected to resume as normal next week with the defense beginning its case. What are you expecting to see now from the defense?
Well, the first thing I'm going to expect to see is an opening statement, because remember, after the prosecution did their opening statement, when they started the trial, the defense decided not to do an opening statement at that time. They reserved their opening statement for a later time. So Monday will be the time for them to deliver their opening statement. So I'm curious what mitigating factors that they're going to focus on to deem that Nicholas Cruz should be worthy of living and serving out his time inside of a prison as opposed to the death penalty. Also, I assume that, of course, they're going to seek out sympathy. Sympathy, sympathy, sympathy. That's going to be their number one focus in order to try to convince at least one juror to hold out when it comes to this sentence.
And I've said it before, and I'll say it again, they don't even have to present that much, where the jury can come back and say, we've seen so much death and destruction in this case, we just don't even feel necessary that one other person should die, and that might be it. Bernarda, Melba, thank you so much. Everyone out there, thanks for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.